Hi, everyone. Welcome to episode 186 of the Immigration Lawyers Podcast. We have our regular episode with Kevin Gregg talking about federal court litigation. It's a fun one. Just a couple quick notes before we start. One is my internet connection is not good, so I'm sorry if it cuts in and out. Hopefully, we get through the whole thing and catch it all. But other than that, please remember the Immigration Lawyers Toolbox magazine is out, the first and only trade magazine for immigration lawyers. Check it out at immigrationlawyerstoolbox.com. And thank you to all the sponsors, IMI Translate, Immigration Finder, DocuWise, Journey for helping out. And DocuWise in particular has been a sponsor of the podcast as well. If you wanted to get a discount off the year plan, an additional discount, just go to www.dockwise.com/immigration-lawyers-podcast, not toolbox, a podcast there, and use the code Immigration Lawyers Podcast. They're a great resource that really help management of attorney law firms, not just the forum. So it's something definitely to take a look at and try out. With that, a reminder, this is not individual legal guidance. This is just general information. But Kevin, great to see you. Thanks for coming on.
My pleasure, John. And your tech gets more impressive by the month. I swear to God, it's very cool what you just did, making us both in the two separate windows. And I must say, I was starting to worry a little bit. I know we're live, and my phone started going off, and I'm like, oh man, I got to put my phone on silent. But my phone was going off because you went live on the immigration on the toolbox. It went live to notify me on LinkedIn and Facebook about this. That's pretty meta. So I don't even know if I can be upset about it. To everyone else, before we went live, John was telling me about all the new events in his life, his move, and how much work he's doing. So the fact that he's here putting on a smiling face is a testament to his commitment to the community. So thank you, John.
I appreciate it. Thank you. It's a great community. It's just so much to do, and then so much, it makes an effect. Some people contact me from the magazine alone that they've learned. People have gotten clients from the magazine. So it's just so much to do to help everyone out and help myself out at the same time. I'm a free market guy, and I like adding to the marketplace of ideas and business that way. But, let's talk about the cases. So there's a really big one I wanted to talk with you about, which is, I think, the 10th Circuit regarding student visas, which is really a disaster. Now, the facts of the case, a guy was accused of rape, and the charge was dropped. I don't know the details if it's true or not, but charges didn't continue. So the guy's got the benefit of the doubt, but the consequences for immigration are horrific. Why don't you jump into that and let us know more about that?
Well, that's right. Well, if the charges that would have been all right. I think he probably would have got out of that. He got charged. He went to trial, and he was found not guilty by a jury. And so the problem is that for the 13 months it took for him to go to trial and to get a not guilty, he was out of status. And as you know, and there aren't that many student visa cases on petition for review, but as you know, if you go out of status, you're out of status. And I don't do student visas that much, but my understanding is you can, try and get back in status, and there are exceptions under the regulations. And maybe even Mr. Awuku Asari could have reinstated his status under the regulations if the violation resulted from circumstances beyond the student's control. He actually might have a good argument for that if he could find another university, of course. But he was placed in removal proceedings and charged as removable under 237A1CI, which essentially is the students who go out of status fail to maintain their status. And it gets even more interesting and beneficial for him because in the 10th Circuit, and I'm not familiar with the case, but apparently there's a case called Lee v. Mukasey. Attorney General Mukasey indicates how old that case is. But in that case, it was talking about a different student visa statute, INA 214 M2, which is, I think, individuals who come to attend secondary schools. And in that case, essentially, the 10th Circuit held you only go out of it if you, the non-citizen, have done something to affirmatively go out of status. That's the only time that provision can be applied against you. And in that case, it was if you terminate or abandon. So that's an affirmative act. You have to terminate or abandon under 214 M2 to fall out of status if you're attending a secondary school. And so that argument was made in regards to 237A1C, but the 10th Circuit rejected it. And that was, according to the 10th Circuit, because the statute uses the passive voice rather than the active voice about terminating or abandoning. 237 says a non-immigrant who has failed
Mm-hmm.
to maintain. And the 10th Circuit viewed that as saying it's just a description of an event.
Mm-hmm.
Doesn't matter why the non-citizen has failed to maintain their student status. If they have failed, then they're screwed.
Yeah.
Harsh ruling, very harsh, of course, for Mr. Awuku-Asari, although good for him, he doesn't have a rape conviction.
Yeah.
I mean, that, you know, it's, I think about that sometimes, you know, it's impossible to make that determination for a non-citizen, right? But would you rather have a criminal conviction, or if you had to pick one, or be removed from this country? I don't know.
I mean, his life, he spent a bunch of money on school.
Right.
He's getting kicked out. Very difficult to be able to come back in anyway. And he always has to have that police record with him whenever he wants to go travel internationally. It's just like, you know, life got, you know, he always bounced back, but it was really disruptive of his life plan. It's pretty bad, yeah.
To me, no one talks about it, but I mean, 13 months in prison and you're not convicted. I mean, necessarily during that 13 months, the man had no conviction. I mean, to me, that's crazy. I understand that you need to imprison dangerous individuals pending trial, but you know, it seems like a lot of the time the individuals who remain incarcerated pending their trial in criminal court are the poor individuals, and the rich individuals usually get some sort of bail pending trial. So I mean, yeah, what was he supposed to do? I mean, this is an interesting question. It's complete ivory tower, but I mean, if he had can you attend class in prison? I mean, can you maintain your student status in prison? Probably not.
Mm-hmm.
And that's why he falls within the regulation if he could reinstate. But yeah, it's a rough one, and I think the 10th Circuit recognizes that, but it's a very textual statutory interpretation type decision, which can be very cold sometimes.
So what else do you got? What kind of other cases popped up that stood out?
Well, you know, we haven't spoken a month and a half, and I tried to limit it, and I will limit it. But the rest of what I've got, a lot of it is on crimes and the categorical approach. I'm not going to get deep into it, but you know, the Supreme Court issued a decision on March 4th, so that's within the last month when we're talking about March cases. And when the Supreme Court talks, you should listen, right? And they ruled against the non-citizen in Pareto v. Wilkinson. It was a decision written by Justice Gorsuch. Mm-hmm. I can't remember how it played out with the dissents. Justice Breyer, Sotomayor, and Kagan dissented, and Justice Barrett took no part. So Justice Barrett has yet to do anything on an immigration type case yet. And this case is, and as I read it, it kind of answers a long-standing dispute about the categorical approach, but also leaves it open. And that's just what I'll get to here. And that is this. Mr. Pareto was removable, and he was applying for non-LPR cancellation of removal, and you can't get non-LPR cancellation of removal if you've been convicted of a CIMT. Mm-hmm. So the question is, was he convicted of the CIMT? The government only submitted the charging document against him. I don't know why the government didn't submit his actual conviction. Mm-hmm. Who knows, right? And Mr. Pareto didn't submit the conviction document, probably because the conviction document would show that he was convicted of a CIMT. But the question the Supreme Court answers is, okay, when it's the relief stage, when the non-citizen has the burden to establish eligibility for relief, and when you have a divisible statute, as was the case with this Nebraska impersonation statute at issue here, mm-hmm. It's divisible into separate crimes. Some of them are CIMTs, some of them are not.
Is this the one with the Social Security number?
I believe so. Yes. Okay, yes.
Oh, sorry.
And so it's a divisible statute. Some are CIMTs, some are not. And we don't know what the non-citizen was convicted of. Mm-hmm. That's a factual question. And the non-citizen has the factual burden on relief, so the non-citizen loses on an ambiguous record. We don't know. Non-citizen loses because the non-citizen has the factual burden. Yeah. To me, I mean, you know, maybe I'm reading it overly narrow because I'm an advocate, but I think I'm right. This situation almost never comes up, right? All DHS had to do was submit the criminal conviction document, and this case goes away because we know what he's convicted of.
Mm-hmm.
The more interesting question is who has the burden on relief when you're not sure whether or not the statute is ambiguous or not. I mean, is divisible or not. That's a legal question. Is the statute divisible or not?
Mm-hmm.
Who wins then? Do burdens matter at all? The circuits are kind of all over the place on it. We thought that Pareto would answer it. I don't think Pareto does answer it because Pareto was narrow, probably with some sort of agreement amongst the justices, to only base it on a factual question when you don't know what they're convicted of. Mm-hmm. But if you know what they're convicted of and you just don't know whether that statute is divisible, I don't think there are any burdens. I think that's just a legal question that the immigration judge needs to answer, or that USCIS needs to determine.
Yeah.
No matter what context it arises in. So Pareto is interesting. I don't think it answers that question. And that question comes up more often. A couple of weeks later, the Fifth Circuit had the very question I just described, except the government had the burden because it was removability. Mm-hmm. And the Fifth Circuit said it's ambiguous. We don't know. He's not removable.
Yeah.
That supports a finding that burdens matter, but it didn't come out and say it. I just don't think burdens matter on legal questions. And there are other contexts when legal questions like jurisdiction in federal court, right? Doesn't matter who has the burden. A court always has to determine jurisdiction or standing on its own. There are some legal questions that burdens don't matter on. I think this is one of them, but maybe the Supreme Court will answer it eventually.
Because I don't handle these cases, I didn't focus too much on that part of it myself, but on the part that the CIMT was using a social security number. And, a vast majority of people here without documentation are using social security numbers, and vast majority of cases are filed, and USCIS never has a problem to make a finding of the CIMT or something like that, which would require a waiver or 601 waiver or something like that. So it's inconsistency of whether social security number use that's not yours or made up is a problem or not. Or if potentially you made it up, but it belongs to somebody, is an inconsistency in the law that we see. And here it was enforced against the applicant or the foreign national. But that's a confusing area that I've seen consistency on in adjudication.
Well, to be honest with you, I didn't even get into the facts. I mean, I don't know if it was that social security number case. That seems right to me, but by the time of the Supreme Court, you and I are just looking at two different things, right? That's indicative of our different practice areas. But sure. I will say, it's dependent on them actually getting a Nebraska revised statute section 28-638 conviction. You know what I mean? It's. I don't think that the statute the case stands for the proposition that all similar crimes necessarily are CIMTs. And as you know, without a conviction, unless your client admits to the essential elements of a crime, and that has an entire legal framework about what constitutes admitting to the essential elements, if you don't have the conviction, if you just used a social security number card, under the law, whether the USCIS officer applies that, even just admitting to having done that doesn't suffice to make a non-citizen inadmissible for having committed a CIMT. The CIMT inadmissibility provision doesn't require a conviction, but what it means to admit to the essential elements is a very important standard. And so, but your point is well taken for sure. And if I had a client who did something similar to what the non-citizen did in a published Supreme Court case, they're all published, I'd be worried too.
And one quick note, one of our listeners, Leonardo, says he enjoys the podcast. Thanks so much for watching, Leonardo. Appreciate it.
Well, whose podcast? We both have one.
We just want to say thanks, John. He's actually podcast. So he doesn't ever join. So there's a limitation on that. But you're here on this one. This is partially your podcast at this point. You're here, so right. How's your practice going right now? How's San Diego and everything?
It's going good. It's San Diego's beautiful, not so far from you. I was actually at the LA USCIS office a couple of weeks ago, naturalized client. So that's a great feeling.
Wonderful.
San Diego's great. Surf when I can. Not as much as I'd like, but still more than I was doing in Miami. The podcast, as you know, it's a labor of love. It's getting really good feedback. The immigration community seems to like it a lot. It helps me a lot. Yeah. And I have fun doing it, but as you know, it is a lot of work. But I just did episode I just published episode 49,
Wow.
and that doesn't include special episodes. So that's 49 weeks, which means I'm 3 weeks away from an entire year, which I just cannot believe is the case. And I'm
Yeah.
going to count the amount of cases I've done on episode 52, which, I mean, I don't know, it's got to be over 300.
Pretty scholar of this stuff. I mean, you become a recognized expert after doing this continuously. So it's really helps out becoming a better immigration lawyer doing this kind of stuff.
It
It's
does, and you know the clients that hire me and our firm, they don't see it, but they're getting charged way less money because I can just do a control find on my master spreadsheet of cases now, and I got a case like that. I know, I know what the argument is. I do way less Westlaw research now because it's just all up here after a whole year, all these cases and all these things. I feel like it's like the Matrix up here. Things are connecting. So it's helped me more than anyone. And if it helped anyone, I'm very happy about that.
well, if you make a library on it, you could market and promote it on the Toolbox magazine. Though you could make a site and get
Well,
it for people.
Well, yeah, so there are plans in the work, but like right now on the Kurzban website, you can go and you can see all of my bullets
Oh, okay.
for every case. You can do a control find. And if you're interested in asylum, and that would be a very generic one, there'd be like 90 things,
Yeah.
but you could do a control find asylum. And if you were only interested in the Fourth Circuit, you would find every asylum case published by the Fourth in the last year.
Wonderful.
And you can do that with statutes, with realistic probability test. I try to make my bullet points helpful to me, and which will lead them. So the Kurzban website has all of that with a control find ability. It's free, so check it out.
Definitely got to. I should have my assistant to edit these out so this portion where we talk about this could be out so people know to use that free service. And we have a Facebook user. Unfortunately, the software doesn't say the name of the person, but they're saying, "I love IRP." So Immigration Review Podcast.
Yeah, that's I've heard people start to say that, which amuses me because that does make sense. I never thought of the acronym, but it's well, thank you for letting me talk about myself. It's always fun, John. But I hope that is helpful because it's helpful to me doing that control find, and a lot of people don't seem to know about that. So I mean, it's really eventually it's going to be like Westlaw for free, or at least a starting off point.
Yeah.
You'll know what cases to find. Another case I like is this Gonzalez v. Wilkinson case, which I've been screaming at the top of my lungs to whoever will listen to me. It's an Eighth Circuit case published on March 9th, but it involves Florida possession. And as you know, I moved from Florida about a year ago. So Florida possession of marijuana, and you know as well as I do, half the country has legalized marijuana, but possession still has these dire immigration consequences. And in this case, the guy possessed it in 2001. He's trying to remove him in 2021 for doing it, or maybe it was precluding him from relief. And this is the simple Florida possession of marijuana statute. And the argument always was with Florida attorneys, not my argument, but made before I was even out of law school, I think, is that the Florida definition of marijuana includes parts of the plant that the feds don't include in the definition of marijuana, specifically some seeds and the stalk. I don't know. But everybody agrees that Florida criminalizes possession, let's say the stalk of a marijuana plant, and the feds don't. And everyone agrees, including the board, that makes the statute of possession of marijuana overbroad vis-a-vis the federal offense because the feds criminalize less conduct than Florida. So it's overbroad. In matter of Guadarrama, a published board decision from 2 years ago, on this very same statute, the board said, fine, it's overbroad, but we don't think, and it's not divisible, but we don't think there's a realistic probability that Florida criminalizes possession of the stalk and the seeds. And so you can't get out of the drug controlled substance removability provision through your creative imagination. That's what they held in matter of Guadarrama. And they did that by, in my opinion, misinterpreting 11th Circuit case law where Guadarrama arose. But putting that aside, and putting aside that that's not really, in my opinion, how the realistic probability test is supposed to be applied, and only the Fifth Circuit applies it like that, The Eighth Circuit in this case is saying, no, that's not how the realistic probability test works. The statute is overbroad on its face. End of story. Possession of marijuana in Florida does not match the definition of a controlled substance offense, even if Florida doesn't criminalize possession of the stalks and the seeds. And that the eighth doesn't even cite the matter of Guadarrama, even though it's directly contradictory to it. So, that's only applicable in the Eighth Circuit, of course, but I think that the rationale in the Eighth Circuit's decision applies in every USCIS office that's in every circuit except the Fifth. Mm-hmm. And that Guadarrama is not worth the paper it's written on. So, and, I'm sure many of us have clients who have possessed marijuana or have a conviction for having done so in their youth. And so it's an important case to remember, and especially if you're in Florida. And that's Gonzalez v. Wilkinson out of the 8th, not even the 11th. So interesting case there.
Well, good stuff. Thanks so much for coming on again. Definitely going to have you sooner. We missed the opportunity to do it earlier because of my movement and everything like that. Speaking of which, I know you like going surfing. We got a pool in a new place, and I'm trying to dip my feet in and swim every day. So, for those on the East Coast, it's March. I mean, it's April, so it is spring, but it's good to be able to jump in a pool this time of year and not freeze your butt off.
All times of the year. Is it big enough for a lap pool? You got like a nice setup. How was your move? How was everything?
4 strokes to reach the other side. It's not bad. There's a lot of rotations going on. No. We were looking for houses, and we looked one house we looked at. The guy had a regular pool for like parties and stuff, and then on a different piece of property, he made an Olympic-sized lap pool. And I really wanted to get that place, but we couldn't close a deal on it. But it was interesting to have 2 pools, one just for swimming laps and one for.
That's the dream. The dream for me is to have an Olympic-sized lap pool, or at least one lane, because that's very cool.
It's interesting with money, stuff you can pull. You do whatever you want. So that sounds fun.
I gotta find some of that.
Yeah, the guy was like a former director of like Star Trek and that stuff, and he was downsizing his house, so he went there. But like it was working on the financing and everything the way they set it up. But we saw over 100 houses, and it's just interesting to see. After the 100th house, we finally found the one we want, and we're so happy we didn't close the deal on the previous ones because. Every time you see a house, like, oh, I like this one. They see the next one, like, I like it too. So finally, it worked and it clicked, and we got one that worked.
Well, congratulations to you. It's awesome. I'll probably be in that position in a year or two, trying to look for a house.
It's a job. It's like a full-time job. And then just dealing with the banks is another job. And now that we're here, boxes and redoing the plumbing, got to redo the roof, probably empty out the pool and repaint it. So it's a never-ending thing. But at least here the kids could break anything they want, and there's no landlord yelling at us anymore. So
congratulations to you there.
I appreciate it. Thank you.
That I sometimes dip my toes into interviewing. Certainly not like you, but every now and then. And actually on Thursday, an interview with the partner at the Kurzban firm, Helena Tetzelli, is going to drop, and it turned into quite the interesting interview. I didn't really have much planned, and we went deep into her past and how she became a lawyer, and then of course employment visas, and which is her bread and butter. So I think maybe John, you'll enjoy it, and if anyone else does as well, that's I like doing the interviews every now and again. It is fun to learn from people and to get them to speak even about themselves. Yeah,
it's a change of pace. You have to connect with people. And it's a little easier than having to do all the studying you have to do.
That's right.
Well, good stuff, Kevin. Look forward to talking with you again. Thanks for coming on.
Bye, John. Have a great month.
You too. Bye-bye.